Good morning, and thank you for joining us today, Thursday, February 20th, on our webinar entitled Employees' Rights and Employer Compliance in California's Consumer Privacy Act.
Did we lose Denise? Well, hi, everybody. We're having a little bit of technical difficulty, as you can tell. So sorry about that. Hopefully, Denise will be able to join us back in. I'm going to ask everybody to do me a favor. Can you just raise a little hand on your dashboard if you can hear me okay? All right, cool. At least we have a couple people that can hear me okay, it looks like. Just want to make sure that, thank you guys so much. Okay, we're going to go ahead and get started. Hopefully Denise can jump back in here. We're just, for some reason, having a little technical difficulty being able to hear her and see my screen at the same time. So welcome everybody to Employees' Rights and Employer Compliance under California's Consumer Privacy Act. Very excited about this presentation today because we have a guest speaker that I will get to in a second. Our moderator, hopefully, will be back with us, and that is Denise Ketty. Denise is with Prevail Marketing Consulting. For those of you that have been on these calls before, these webinars before, you know that she is our moderator. She also does our social media marketing, our newsletter every month, and she is a marketing consultant. She works with a whole bunch of different clients, and she is a lot of fun to boot. So we're excited to have her with us today. Our legal expert is typically Marla Robinson. Today, Marla had another engagement, so she asked Curtis to fill in for her. Most of you know that Curtis is an associate with Merhab Robinson. He is part of the transaction department, but also has a specialty in employment law. I just realized, Curtis, we need to update this slide because it has your firm's old contact information on it, but the phone number will still work. Curtis is an expert on a whole bunch of different things, and he also actually teaches law. And most recently, he has been named, again, a rising star. I'm very proud of that graphic right there, just so everybody knows, a rising star by superlawyers.com. So Curtis, congratulations on that. You guys all know me, president of Ethos Human Capital Solutions. Started the business in 2007, and we've been working with small business owners for the last several years to provide them with recruiting, training, and HR consulting services. I am going to tell you some very exciting news that we wanted to share with everybody. We have recently, as of last week, been certified as an approved provider with the HR Certification Institute. So for those of you that aren't HR professionals, I'll just tell you that this is the body, this organization has for a long time been sort of the standard in certifying HR professionals with a certain level of expertise. So if you notice, like on my signature, for example, it'll have an SPHR after that, which is a senior professional in human resources. So originally back, I think 99 or something, it's been a while, had to pass an exam, and then you have to have so many recertification credits every 3 years in order to maintain that certification. And so we are now able to provide those classes for people to get certification. So if you are on the webinar today and you need recertification credits for that, what I'm going to have you do is type HRCI over to in the question pane over on your dashboard, and because we'll be able to retain that information and we can send you a certificate of completion afterwards. You will have to complete our survey, our evaluation, because that's part of the rules for HRCI's certification process, but we can provide you with that with that afterwards, so you can get 1 hour of credit for today. Denise, are you back on with us by any chance?
Yes, I finally am. So,
okay,
and I see that somebody's already typing in, so that's great.
Perfect. I did not do our normal preamble, so do you want to do that?
Oh, yes, I'll go quickly.
We move on. Okay.
Sure. So I wanted to thank everybody and appreciate everybody hanging with us while we go through this. We wanted to let you know that the webinar will run about 60 minutes in total. Take a moment now to please visit the handouts area on your dashboard to download a copy of today's presentation. If you have questions during the presentation, please post them on the Q&A area of the dashboard anytime during the presentation. If you would like your question directed to a specific panelist, you can note that when you're sending in your question. If you have any issues arising during the presentation, you could email me directly at denisemkeddy@gmail.com. Just a quick reminder before we start the presentation today that our webinar is being recorded and all accompanying materials are protected copyright. Our presentation today provides general information and does not constitute legal advice. The information offered during the webinar is as of today, February 20th, 2020. As always, we recommend that you consult with your own legal counsel to address your specific situation and ensure that you have the most current information on legal matters. With that, I know you did the introductions, Linda. I'm going to turn it back to you so you can talk about today's exciting presentation.
Thanks so much, Denise. Okay, so I am very excited about today's presenter, Linda Zimmer. I consider her a good friend. I've met her about 12 years ago, and I actually, the first time I ever met her is when she was speaking, and I was in attendance, and I was mesmerized. I ask her to speak as often as I can in any organization I belong to, because I learn from something from her every single time she speaks. I think she's brilliant, and that's why I also hired her to create our current website. So if you go to ethoshcs.com and you like our website, then you should reach out to Linda about having her create one for you or update the one you have. Today, however, Linda's here to speak about privacy. And for over 30 years, Linda has been on the forefront of working with data and online marketing. As she says in her LinkedIn profile, data analysis is her playground, which I love that phrase. And because of this, about 4 years ago, she became a certified privacy protection manager. I don't know about you, I'd never heard of that before, but Linda had the foresight to see where the world was heading, and so she did that. So in addition to working with companies on their wicked smart marketing strategies, she also works with them to review how they're handling their data and to put processes in place to properly handle data. And so I'm super excited that you're here to hear what she has to say on this important topic, and I am going to do my best to actually turn the presentation over to Linda now.
Excellent. Hopefully it looks like everybody can see my screens. Thank you both Denise and Linda, and I'm so glad that Curtis is here to back me up on the legal side. So please do feel free to throw questions in as we go through this. I do want to preface this with saying that what I'm going to go over today is kind of a general overview of this really interesting, very comprehensive, slightly confusing, and pretty big deal law that has gone into effect basically as of January of this year. So we're well into the compliance piece. But the reason I'm doing a general overview is because, number one, it impacts human resources data. And so all of you that are in the HR function, this is going to directly impact you. But also part of the requirements of this law is that we provide employee training. And so some of this overview might be very helpful for you as well in just training your own employees as to what this law is and how it may impact them in their daily function. So with that, I do need to repeat that little disclaimer. I am certified as a privacy manager, so helping companies put processes in place and recognize what data has to be protected under various sundry federal, state laws and regulations. I'm not an attorney, but Curtis is, so we do have some legal heft here on the call as well. So What I'm going to go over is some of the basics regarding the compliance, but keep in mind, as Denise has also said, that you do need to check with your own legal counsel because this law will apply to everybody in different ways and help manage your risk associated with the liabilities associated with compliance as well. So please, please, please check with your own attorneys. So first of all, just in case you're really interested in digging into what these laws are, we first had AB 375, that is known as the California Consumer Privacy Act of 2018. That is the formal title of this law. It was passed in June of 18, and it's gone through several amendments. But basically, it became effective, as I said, on January 1st, 2020. And there are, thank you, some employer exemptions which will impact you. So we'll be going over those today until January of 2021. We're right in the process of waiting and seeing and reviewing what the Attorney General's office is coming out with as far as draft regulations. So his office did release some draft regulations on the 10th of this month. It is now in the public comment arena right now, time frame, and those comments are due by February 25th. So if you want the chance to get in your comments, you do have that right to go and do that. So we're on draft regulations version 2.0. So I will try to address some of those pending regulations as we go through this as well. So, and I'm happy to take your questions. So before I get into the specifics, I do want to warn you that while there are very specific things within this law, one of the things that you have to recognize is this just reflects larger trends that are going on in terms of data privacy. And one of those trends is giving people more control over what happens to their data. And all of the laws that California are looking at and passing, and we now have a federal law that has been introduced that will create a federal Office of Privacy Protection. So this is just not going to go away. So regardless of whether you technically come under the threshold of this law, which I will give you in a couple of seconds, recognize that this is going to filter down to everybody over the next few years anyway, because the trend is both from a consumer perspective, from a marketing perspective, consumers are concerned about their data, they're concerned about leaks, they're concerned about having to supply so much data and what happens to it. So we're going to see lots more legislation coming out. And now that California has passed this law, we're seeing several states pile on and do similar things too. So pay attention, even if you don't technically fall under the constraints or the thresholds for this law. So what does this law do? It, first of all, establishes certain rights, and I put consumers in quotes because it is called the Consumer Act. However, employees are considered consumers under this law. So consumers, where I say consumers, you can also put employees in there, as well as owners, independent contractors, anybody and everybody is defined as a consumer under this law. So this law establishes certain rights, and we're going to go over what those rights are. It requires a process, so you may have to develop some new processes around where and how people can determine what personally identifiable, PI, personally identifiable information that you hold or that you transfer about them. So they have to have some way of requesting this information from you, which means that you're going to have some procedures on the way you maintain this personal information within your systems. In the HR function, you're really used to this, so it should not be a huge burden. That might not be true throughout the rest of the organization. But you are going to need a procedure that allows you to respond to consumer requests for what information you hold and transfer. And generally, you need to respond within 10 days that you've received the request, and you need to fulfill that in 45 days. So you're going to probably have to do some streamlining on that. And then the last thing, of course, no law is a good law unless it has some kind of liability and enforcement arm behind it. So the law also gives us a pretty clear picture of what our risk profile looks like in terms of enforcement action by the Attorney General. Okay, so here is how a consumer is generally defined under this law. It's any natural person, any person. So I'm sure there'll be questions about B2B on this, but in general, this is about actual entities, people walking around. And this includes, of course, customers, but it also includes current and former applicants, current and former employees, directors, owners, independent contractors. And one of the big things about this law is it has broadened this definition of consumer to include households as well as devices. And when we talk about devices, we're talking about everything from mobile to web to Alexas and all of our voice assistants, etc. So in the HR function, that is going to actually impact things like who dependents are, beneficiaries, contact information. All of that information that you hold is subject to, quote unquote, being a consumer's personal identifiable information. So it's basically every individual that resides in the state, except if they're temporary, of course. And then even if they're domiciled here, but they happen to be living or operating elsewhere, they are considered a California resident, even though they may not actually be physically at the moment. In California, they are, if they're domiciled here, then this impacts. So that's another way of saying that even if a business is not located in California, but is collecting and processing information on Californians, they're subject to this law. And of course, this is where it's important to talk to your legal counsel about that. So here's how this actually reads in the law, that under the CCPA, employees are consumers if they're a job applicant, an owner, an employee, a director, a medical staff member. Some companies have medical staff, and then, of course, independent contractors. Now, under this law, there are some rights that become effective immediately, are in effect now as of January 1st. But as of January 2021, they get full rights under the CCPA. So right now, we're going to focus on a few that are applicable today, but many of the things that I mentioned here are coming. They're barreling down on us. Time goes by fast. This is pretty comprehensive, so I would encourage everybody to just act like it's in effect now and get started on it, because January 2021, unless there's been some major regulations that the legislature puts through to amend AB 25, employees will have full rights under this law. And just in general, the things that we're going to be talking about today that CCPA encompasses, things you've got to be thinking about, is it massively expands the definition of personal data. And I'm going to give you a bit of a checklist here on all of the things that may be considered personally identifiable information or personal data. Things that are going to impact you now is you will need to give employees notice, and that is in effect now. So we'll go over that as well. how you're storing the data. I know that you are probably tackling that as well as retention and deletion with your HR data. So there won't be a whole lot new there. Those procedures are still going to be pretty much intact. But data security is something kind of new too, because this law does give employees the right to sue you for a data breach. So in essence, these are the things that we're going to kind of be touching base on today, but pretty much all businesses that capture information from California residents are going to be included in this sweeping law, except that there are some thresholds. So these are the people that are the entities that must comply. If you're doing business in California and you meet one or more of these criteria, you do not need, not all three, one or more. So if you have more than 25 million in revenues, you fall under this law and you need to comply. If you hold or process more than 50,000 consumers, including employees, including customers, including households, including devices, you also fall under this. And that includes any data that you purchase or share in the last 12 months. So if you have third-party data that's being shared, either way, to you or from you, you may be subject to this as well. And for online businesses, it's not that hard to meet this 50,000 threshold. So don't just think about it as employees. Think about the entire business organization and how many potential consumers, quote unquote, that you are holding data on. So 50,000 is not that much. And then this doesn't probably apply to most of you, but if 50% or more of your annual revenues come from the sale of personal information, you are definitely falling under the compliance here. One kind of nuance that I will mention is that any entity, and this includes nonprofits. Now, generally, nonprofits are not subject to this. You do need to be a for-profit business, unless you're controlled by or you share branding with another entity, another company that meets these thresholds. So that's a nuance. Most of you probably won't have to worry about that. But if you are an affiliate with another company that meets one of those three criteria, and you are jointly collecting information either alone or jointly, you do fall under this law. So this, again, might be helpful to turn to your counsel to make sure you are excluded or that you are swept up in one of these three criteria to meet that threshold. Okay, now this idea of selling, we can dismiss it, say, yeah, we don't sell it, except you do need to do a little bit of due diligence around your data, because the definition of selling data is not just receiving dollars. It could be you're renting it, you're leasing it, you're sharing it, you're transferring it. This is where your third-party vendors might come into play. So if you're communicating this personal data by any means, electronic, paper, or anything, for any kind of valuable consideration, and these were the regulations are going to help kind of clarify what this means. But in general, if you get price discounts for sharing data, if there's some other valuable partnership kind of arrangement, if you're getting valuable consideration for that, you do want to kind of do a little due diligence on this. And the reason that you do, because most of you are probably somewhere in your supply chain of information, likely sharing information with a third party. And the definition of the selling or transferring of data is a really important one, because if you're sharing this with a third party and it meets certain criteria, then it means that you're not selling data. You're sharing it with a third party for purposes of business transaction, and that does not meet the sale definition. So actually, it can save you to really be clear on your vendor relationships, that you're not actually receiving valuable consideration for it, and document that. So we'll get into that a little bit more in a couple of minutes. So let's look at what this massively expanded personal data actually refers to. So pretty much anything that relates to a person, identifies a person, describes a person, could be linked with that person, is somehow associated with that person, or with a household, it is defined as personal data. But we're going to look at something more concrete than that to kind of help you define what that really means in terms of practical day-to-day definitions of personal data. So let's look at some of the things that actually fall under this. And this is not new because a lot of this falls under personally identifiable data for other privacy reasons, but this has been expanded and does impact HR in kind of a unique way. So obviously, a real name, an alias, contact information, an employee number, which might be a unique identifier. There might be lots of unique identifiers. An online identifier, meaning a username. Internet protocol addresses, email, social security, of course, driver's license, all of that. But what gets really interesting is things like physical characteristics, the employment history, along with things like browser history. And then as we move down this list, of course, protected classification, but audio or visual or thermal information. So this is trying to keep ahead of all the technology. So if you have oral recordings or any kind of audio recording for voice recognition, for example, that falls under personally identifiable information. Images, video is what is meant by any kind of visual. And then thermal, a lot of the biometrics that we might be using for badges, for eye scanning, that kind of information is now considered part of that personally identifiable information. And payment history, this includes for your independent contractors, time, wages, all of the information that you're collecting from your independent contractors, and of course your legal records, your I-9s, and I know that Linda and team have given you some really good best practices around that, keeping those things a bit separate. But all of these things are probably not, aggregated in a particular place. They're probably in many places throughout your organization. And so you're going to need to be a little bit diligent about going and finding where all of this information is, because as either an employee or as a customer, you have the right to know what kind of this information you as a business entity are holding or processing on their behalf. So as I said, it massively broadens the definition of personal data. And this is where it kind of brings some challenges into us on the professional side, is figuring out where all this data is in your organization and how you're processing it. So let's look now at what are your employee rights as well as what general consumer rights are. And do pay attention a little bit anyway as to what the general protections are, the rights are for the consumer side, because again, you're going to need to be training your employees on this. So they're going to need to know. So first of all, the first two here that you see in bold with an asterisk does apply to employees. They have the right to know what personal information is being collected, and Luckily, with new regulations, we don't have to do a backward look necessarily on everything that has been collected, but what is being collected currently related to them and what information you are currently processing about them. And then they also have the right to know what information is being either sold, in that broad definition of sold, or to whom you are disclosing this information. So this is where your third party and your service providers may come into play. They have a right to know who those entities are and what you are disclosing or sharing about the employees, about them. Then, of course, what this law has given everybody a right to do, and eventually this will also apply to the employee, and that is to prohibit the sale, under that broad definition of sale of personal information. They do have the right to ask that information be deleted, and that you need to, if you're under contract with certain service providers, that provider also may need to delete that information. We'll look at that a little bit closer in a minute. And then this mostly applies to the customer kind of consumer, and that is if they do opt to exercise these rights, they cannot necessarily be discriminated against, and that they would get equal service. There are some exceptions, which we're not going to drill down into today, but if you can justify the difference in service based on sharing their ability to share that information, you can justify it. And then also this employee notice is also a right that they have. So you're going to have to update certain employee notices to be compliant with this law, and including your privacy policies, which are in existence. You may have to tweak some of your language around that. In general, for most everybody that falls under this, website notices are now going to have to be tweaked and added. There is a requirement for a do not sell link that needs to go up on the website, or at least a link that makes it very clear where people can exercise the right to get the information that you hold. And then it's going to require you to develop some processes around this, as I noticed a little bit earlier. So the ones that you see here with the asterisk, these are already in place. You need to be compliant with these right now. That is as of the January 1st. And then all the rest of these kind of follow, especially for employees. For employees, you have this period up until January 1 of 2020 to provide all the rest of these that do not have an asterisk beside it. So the three big important ones for today are the right to know, to whom this is being disclosed, and then the new employee notices. So let's take a minute and kind of drill down what's very specific to employers and employees. Employees, again, would include directors, contractors. These all have the same rights under this law as quote-unquote consumers. So right now, as of 2020, as I said, you have to provide notice of the collection of categories of employee data, and for the business purpose that you're doing that. Now, some of the new regulations that have come out have kind of lessened the blow on this, but let me talk a little bit about what some of those categories might be, and I'm happy to provide a list. I probably should have done a slide on this, but what do I mean by collection of categories of employee data? So these are categories, things like contact info, obviously. Employment info would be a separate category, resumes, job applications, etc. Government identifiers, social security numbers, that would be a separate category. Biometric data, which we've talked about. Relationship data, this may come into play with your employee benefits. You're collecting various household information. Interestingly, this law even talks about what they call inferred data. So things like attributes, personality characteristics. If you do various kinds of assessments of individuals or teams, that kind of information is now a category of information that you need to disclose, including if you create some kind of internal scores related to that information of various assessments or skill sets. So when we talk about inferred, it might be a skill set that this person has as well. And then, of course, there's demographic information, transactional. There might be this audio-visual. That's considered a separate category. Health information, online and technical. So that pretty much covers most of the categories. But originally, this law was you're gonna have to disclose every little piece of information, and luckily the new regulations, and Curtis can correct me on this if I'm overstating this, but generally we're sticking with categories right now that need to be disclosed. So that is helpful as opposed to every single piece of information having to be disclosed. So you also need to have security measures in place for all of this data because, as I mentioned before, employees can sue you now for data breaches. And there is a new right of private action in this law that allows the consumer to sue you as well, which in general hasn't been quite as easily accessible to a consumer as it is now under this law. So this new regulation and some of the new draft regulations loosen up this last bullet a little bit, but you do need to create a new notice of previously collected personal information unless it's not materially different than what you originally collected it for. So obviously, if you have information that you're collecting for a particular business reason and you're going to continue to use that, you do not necessarily need to go back and give them new notice about previously collected information. However, if you take some of that information and you use it in a way that it was not originally notified, that wasn't notified originally, or you're using it for an entirely different purpose, an obvious one would be you taking a photo for a badge, and now you decide to use it on the website, and that's public. You will have to give new notice on something like that because it would likely be considered materially different than the reason that you originally collected this information for. So it can get a little bit sticky, but again, you're going to have to look at your current use of this information and what you have disclosed in the past. Probably it's not materially different, but it is a good due diligence to make sure that you're using it for the intended purposes, because even under other California privacy laws, you do need to disclose what the purpose of that information, the business purpose of that information is. So what are you exempt from until 2021 as an employer? So right now, if you're collecting information on employees and applicants solely for employment, your usual HR, run-of-the-mill business HR data, you don't need to worry about a lot of the, very super specific things that full rights coming into effect January 1st, 2021. So HR data has sort of been given a reprieve here, so you do have time to kind of get our act together in terms of where is this data and did we previously disclose and all of that. So once 2021 comes around, though, you will have to disclose and give full rights to employees. Now, this also means that if your employee is also a consumer, like a customer of your business, you're not 100% exempt. If they're also a customer, they get full rights as a customer. So someone asked me the other day, well, what do you mean a customer? I said, well, what if you're an employee of Amazon and you also are a customer at Amazon, right? You order things on Amazon. You fall into both camps. So you might be, in that case, HR data might be exempt until 2021, but that the right for deletion on the customer side still exists. Another thing that still fully exists right now is that if third parties are collecting information on voluntary activities, what's a voluntary activity? Like a health and wellness plan that you might have in place, for example. Those kinds of things, the employee has full rights as of now for deletion requests and knowing what information you hold. So if you have any kind of those employee programs in place that are voluntary and collecting information, that falls under compliance right now. Now, there are two other really big exemptions to all of this HR information that we might be collecting, and that is things that fall under HIPAA's personal health information. You may be exempt from some of this under the ERISA information that you might be holding. And that also includes the Fair Credit Reporting Act. And the reason for these exemptions is they all have their own regulations. And so the Attorney General and the law basically comes out and says, okay, as long as you're complying with all of that information and those regulations, you don't need to also kind of, how does this regulation overlap with those regulations? I will say, though, that again, here's where you need to do a little due diligence, is this exemption applies to HIPAA's definition of personal health information. And there might be information that you're gathering that falls outside of health information that becomes now just regular old PI, personal information, that may not be exempt. So you do need to look at this a little bit carefully and not just broad sweep say, oh, this stuff is all HIPAA, no problem. You need to kind of do a little nuanced look at that. And so now when the calendar turns again, these are the things that you're going to need to expect to have to do. So you're going to need those expanded disclosures. And this one is a little bit up in the air because there are pending regulations. We may not have to move away from categories to all pieces of information, as the law now states. So it looks like we're leaning towards just having to disclose categories, but we have to wait to see what the final regulations are around that. You will need to be able to give notification if the information is being shared with third parties, and what those categories of third parties are. So if they're, for example, an HR service provider like payroll, perfect example, that's a third party that you're selling, that you're not selling, you're sharing. That's employment types of third party. But you might also be sharing with, let's see, what's another good example of a third party? You may have some data analysis company that your customer information and your employee information is being shared with. So those kinds of categories would also have to be of who your third parties are. You will, as of January 2021, have to implement two methods that an employee can submit personal information requests. And one of those is a toll-free number, but you can also have a web form. New regulations are saying that an email address suffices. You don't have to have a web form. You could just provide an email address, but you do need 2 methods for the employees to submit a personal information request. And then, as I said, you do then need to hand over this information within 45 days. So the employee or the customer has the right to get all of that information from you, not just disclosing what that information is, but you actually need to provide them a copy of that information. So this is where new processes and procedures will probably come into play. So just to sort of recap a little bit, this does require notice. These are the things that will be required in your notices. Categories of information collected, what's sold, category of information that is shared with the third parties, categories of information that the business discloses about the consumer for business purposes. So most of your notices probably already encompass this information, but it would be a good idea to go check and make sure that that information is being disclosed. And I'm going to give you some examples of how others are doing that now. So here's an example of notice at point of collection. This law states, especially for employees as well, that you need to provide notice at the point of collection. And you can go about this in several ways. These are a few examples of what that might look like. So this organization, if you go to their website and you might be filling out an employee application, notice over on the left, they have a very specific privacy notice, terms of use, their cookie policy. We're sort of used to dealing with all of those things right now. And they've added 2 links that make them compliant here. One is the notice at collection. So they've kind of done a general approach here. Here's the notice, and here's the important information that you need, and here are links to the more detailed privacy policies and policies around this, where you can go get that information. So if you notice the second bullet up from the bottom here, there's a privacy notice specifically for California residents, as well as the third one up from the bottom, which is do not sell my personal information. That is a requirement that we give people the opt-out on that. And then the very first bullet there, information we collect and the purposes for which we use it. So this kind of encapsulates the kinds of disclosures that will be needed on your end to be fully compliant with the CCPA. So here's another example of the way a company has provided this notice. And this one happens to be specifically for employees. So this is a really nice kind of snapshot way of doing it. Is they've provided the categories over here on the left. And obviously this is not comprehensive. It's what would fit on my slide, but you'll see that they give examples of each kind of information. And this is a really good best practice. So identifiers, your name, your postal address, social security number, characteristics of protected classifications. So that would be race, origin, age, those kinds of things. And then whether that the information is collected, yes or no, whether we disclose it or not, yes or no, and whether we sell it or not, yes or no. And again, that's where doing a little bit of due diligence on whether you fall under the sell, not sell category would be a really good idea. But the last one here, professional or employment related information, job application, past and current job history, and your job's performance information. So this is kind of a nice, clean way to do it. It really is really beneficial for the person that's trying to get this information to be able to see that in a snapshot. And then
Linda,
you may have, yes,
Linda, let me bust in here just for a second.
okay,
A couple reasons. One, just to give you a heads up on time.
yeah, I
And then
just noticed.
also, is there a way for people to get sample notices, or in the law itself, does it give you any sort of samples that people could then take and adjust for their own business?
It does. The law does not. Nor now the AG may come, the Attorney General may come out with that as they're revising and updating the final regulations. But currently, no. There's certainly examples online that you can see, but no, there aren't like templates. So let me run through the rest of this rather quickly. So some of your service providers may have automated systems, so check in with them. Like this one creates pop-ups on the website for that at point of notice. So training is something that you as HR professionals are probably going to have to facilitate. So these are the things that people who and for what you need to train. So first of all, any individual in your organization that's responsible for handling the procedures around this notification, taking in those requests and responding to those requests will need to be trained. And the things that they're going to need to be trained on are pretty basic things like what is personal information? How do we direct consumers to exercise their rights? What are our procedures for the consumer to be able to do that? And then, of course, they should know what the consequences are around not complying with this. And most especially, not using collected information for the purpose that, other than the purpose for which it's been specified. So you'll probably also have to create some processes, and you've got the slides, so I won't go over all of these, but you do need to update your privacy policies every 12 months, and you do need to provide employee training in addition to being able to deliver that information within 45 days once it's been requested. And you'll probably also need to develop some procedures. Some of these may already exist in your organization, but you'll have to provide the notice. How do we provide access to copies of this stuff? Generally, it has to be exported into some kind of, typical format. How do we delete all of the information throughout our organization if we get that request? So all of these procedures are things that you probably are going to want to look at and pay attention to over this next year to be sure that you have those in place. The third-party exemption, again, I've already kind of gone over that, but I do want to say that it would be really important for you to be sure that your service providers are under contract to, if you get an information deletion request, you need a procedure to notify a third party who's processing information on your behalf that you've received that deletion request, and they should be under contract that they will adhere to, even if they're not in state, that they will adhere to the compliance that you need to provide under that third party. And again, this is where your legal counsel can really be helpful. There are some deletion exemptions, and that is basically you need HR information in order to pay people, employ them. And so if you need to complete certain transactions, as sweeping as this law is, you obviously cannot just delete all your HR information because you've gotten that request. For any of those ongoing transactions and legal obligations, that is a reasonable business operational reason to be holding that, and you are not obligated to delete that information. Liability can be kind of stiff. The intentional is $2,500 per violation. That's per person, per resident, per household. And then actual damages are somewhat a little less scary, maybe $100 to $750 per violation. But you cannot ask the consumer or employee to waive their rights under that liability. So I will kind of skip through this to give you your practical checklist of what you should be doing right now. As I've mentioned, you should be mapping that data. You need to review your security measures, do those notices, establish a toll-free number, provide 2 ways in which people can access and request that information. Train your staff, and then create those processes for compliance. Do add this information and these notices to your onboarding, to your manuals, and to your annual training. That is going to be a really big important thing if things go south and the AG comes knocking on your door for some reason for noncompliance. Having those best practices in place is really going to be helpful. So I am going to turn this now over to Linda. I'm happy to take questions. We have just a couple of minutes, and I will give it back to Linda.
Okay, actually, I'm going to jump in. It's Denise.
Okay.
Thank you, Linda. I know I just wanted to get a couple of things in. If we don't get to your questions today, we promise we'll follow up. If you have questions, please put them in the Q&A section right now. Just a reminder, if you got onto the webinar a few minutes later, if you want HRCI credits for this webinar, Linda Duffy announced that she can provide HRCI credits. Please add that also into the Q&A section of the webinar so that we know we can send this to you. Okay, so we only have like 2 minutes, so I wanted to get to a couple of quick questions. So you mentioned, Linda, that employees own their own data, but what if they're using a company computer or phone? Are we allowed to inspect it? What about inspecting the lockers and desks on company property? I think that might be a Curtis question.
Yeah, Curtis, you want to take that one?
Yeah, I can jump in on that one. So even though we have the CCPA, that does not prohibit an employer from inspecting employer property or inspecting items that are on an employer's property. Even though California has strong privacy rights for all of its citizens and residents, so certain privacy rights can be waived in the employment context. And the rights that can be waived are not affected by CCPA. So you can still access company emails even if they're assigned to a specific employee, and those emails might contain employee data because it's still company property. Now, what you do with that information is going to be subject to CCPA. You can still inspect company property despite the CCPA restrictions.
Okay, great. We have a couple other questions. Linda, can you please review the criteria that causes a business to fail under this, or fall under this law, sorry. If we don't meet any of the criteria that you talked about, will we be exempt? Will this affect us in the future?
Yeah, and again, I would say you always want to check with your legal counsel, but the 3 criteria are 25 million in revenue, that you collect and hold information on 50,000 or more California residents, and that if you make 50% or more of your revenue from the quote unquote sale of personal data. If you do not meet that threshold, this compliance with this law does not apply to you. But I would say stay tuned and just keep your ear to the ground because number one, with this law, consumers and employees maybe have an expectation that they're going to be able to control their data, meaning exercise their rights of control over it. So you may be sort of pressured by just market forces on this, but technically from a liability and compliance, there is no enforcement if you don't meet those three criteria.
Great, thanks. Linda, do you want to jump in?
Yeah, thanks so much, Linda. And we so appreciate your expertise on this. And everyone on the webinar will notice if you have questions regarding privacy, my name's not there. So please contact Linda Zimmer. If you have a legal question, reach out to Curtis so they can be able to help you. And again, I apologize, Curtis. We need to update your contact information on that other slide. So we'll make sure that that happens. But this is his correct email on this slide. I'm really excited about next month's webinar, March 19th. We've got special guest speakers again. So Sean Larson and Joseph Nadur, who are with Larson and Nadur, they are litigators. And this is actually now who Marla refers all of her litigation out to. And I've asked them to come and talk and tell war stories basically about what they've seen. What I like about Sean and Joseph, besides they're just smart, great guys, is that they have been on both sides of the table. So they have traditionally represented employers, but they also from time to time will take on an employee lawsuit. And so they look at things a little bit differently than a lot of people who are only on one side of the table. So they're going to come and tell some war stories. There's going to be a lot of learning points here. We'll talk about what to do and not to do to avoid sexual harassment lawsuits, talk about the whole independent contractor and where employers have gone wrong with that. They've got some PAGA stories to tell you to make sure that you're in compliance with some wage and hour laws, give you some best practices regarding wage and hour compliance, like with regular rate calculations and meal and rest periods, and some common mistakes they see employers make managing leaves of absence. So we just want to make sure that everybody hears about different things that go on that they see on a regular basis and sort of the what not to do. And again, we're really pleased that we can now offer HRCI recertification credits. So I noticed a few more people drop that in. If for some reason you remember later you want that, just shoot me an email. And if I have to make sure that you're in attendance, but once I do that, I can send you a certificate of attendance for your records, and it will have the official 6-digit number on it, so you can just put that in their website, and you don't have to enter all the information in separately. And with that, I'm going to say once again, thank you so much, Curtis and Linda, for helping us out today. And Denise, as always, thank you so much for moderating. And to everybody else, have a great rest of the week.